Welcome back to Criminal Law class. In today's class, I will explore what is voluntary intoxication compared with involuntary intoxication, how defences of voluntary intoxication and involuntary intoxication apply to an offence which is a specific intent crime compared with a basic intent crime, and how courts view dangerous and non-dangerous drugs. When considering whether a defendant has a defence, it is important to consider two basic steps. Step 1. Did the defendant consume or take the intoxication voluntarily or involuntarily? And step 2. Is the defendant accused of a specific intent crime or a basic intent crime? Let's look at the first of these steps about voluntary and involuntary intoxication. Step 1. Did the defendant consume or take the intoxication voluntarily or involuntarily? To answer this question, we need to understand what is voluntary intoxication compared to involuntary intoxication. Well, voluntary intoxication occurs when a person knowingly and willingly consumes alcohol, drugs, or another intoxicating substance. Examples of voluntary intoxication include drinking several pints of beer at a local pub, taking recreational drugs like LSD or ecstasy or cannabis, or misusing prescription medication deliberately. Now, involuntary intoxication occurs when a person becomes intoxicated without their knowledge or against their will. And examples of involuntary intoxication include having a drink spiked with alcohol or drugs, being given medication unknowingly, or experiencing unexpected effects from properly taken prescription drugs. Let's now consider step 2. Is the defendant accused of a specific intent crime or a basic intent crime? The second step requires you to understand what is a specific intent crime and a basic intent crime. This is because knowing whether the offence is a specific intent crime or a basic intent crime is important as to whether a defence of intoxication is available with respect to whether the accused was voluntary intoxicated or involuntary intoxicated. Let me explain further. What are specific intent crimes? These are offences where the mens rea requires intent and nothing else, and therefore excludes crimes that can be committed recklessly. Examples of specific intent crimes include murder, theft, robbery, Section 18 GBH. So let's ask this question. Can voluntary intoxication be a defence to a specific intent crime like murder? In short, the answer is generally yes. A defendant may use evidence of their voluntary intoxication to argue that they were so intoxicated at the time of the offence that they lacked the mens rea entirely for the specific intent crime. The effect of the voluntary intoxication is the defendant is incapable of forming the necessary intent to commit the relevant specific intent crime. Now, the case of R versus Majewski can be used to establish this principle, that the effect of voluntary intoxication means the defendant is incapable of forming the necessary intent to commit a specific intent crime like murder. However, there is one exception where voluntary intoxication cannot be relied on as a defence by a defendant to a specific intent crime. These cases are called Dutch courage cases, where the defendant deliberately consumes alcohol or drugs in order to gain the confidence to commit a criminal offence. In Dutch courage cases, a defendant may not rely on their intoxication to negate the mens rea, even for specific intent crimes like murder, assuming the intoxication was taken voluntarily. In Attorney General versus Northern Ireland versus Gallagher, the defendant decided to kill his wife and drank most of the bottle of whiskey to give himself Dutch courage. The House of Lords held that a defendant could not rely on voluntary intoxication if they had the mens rea for the crime before they started to drink. Turning now to basic intent crimes. What is a basic intent crime? Basic intent crimes are offences which can be committed intentionally and recklessly. Examples of basic intent crimes include assault, battery, Section 47 ABH, Section 20 wounding, constructive manslaughter, criminal damage. To complicate matters, courts have said sexual offences like sexual assaults, which can only be committed intentionally and not recklessly, are to be considered a basic intent crime, as per the case of R versus Heard. This case seems to establish an exception to the general rules defining specific and basic intent crimes. Now, in R versus Heard, the facts were the defendant was drunk and rubbed his pee against the victim's leg and was convicted of a sexual assault. He appealed on grounds that sexual assault should be considered a crime of specific intent. However, the Court of Appeal were not impressed and said it was a crime of basic intent, and therefore the defendant's conviction for sexual assault was upheld. Let me now turn to a series of questions. Question: can a defendant rely on voluntary intoxication for a crime of basic intent? The answer is no. Voluntary intoxication for offences of basic intent will not deprive the defendant of the mens rea, as per the case of R versus Majewski. The facts of this case are the defendant consumed alcohol and drugs, then assaulted several people in a pub, including a police officer. The defendant argued he was so intoxicated, having consumed drugs and alcohol, he was incapable of forming the necessary mens rea. However, again, the court was not impressed and held intoxication was voluntary and that recklessness in becoming intoxicated was sufficient for the mens rea of basic intent crimes. In short, voluntary intoxication is not a defence to a crime of basic intent because the defendant's conduct in getting voluntarily intoxicated is in itself reckless. Question: can a defendant rely on involuntary intoxication as a defence to a specific intent crime or a basic intent crime? In short, the answer is yes. For involuntary intoxication, the law does not differentiate between offences of specific intent crimes or basic intent crimes, as per the case of R versus Hardy. If a defendant lacks mens rea as a result of involuntary intoxication, for example by having their drink spiked, then this will mean he has no criminal liability. Question: what does the law say about dangerous and non-dangerous drugs? The law differentiates between dangerous and non-dangerous substances and drugs. Dangerous substances include alcohol and illegal drugs. Dangerous substances are treated like alcohol. This means a voluntary consumption of taking a dangerous drug will afford a defendant a defence for a specific intent crime, but not a basic intent crime. Alternatively, a non-dangerous drug substance includes prescription drugs or substances taken for a legitimate medical reason. So question: can taking a non-dangerous drug be a defence? The case of R versus Bailey provides an important principle and answers this question. In this case, the facts are the defendant was diabetic and failed to eat after taking insulin. He became aggressive and hit someone. It was held, although he took a non-dangerous drug, the defence would fail if he was reckless in managing his condition. The principle established that a defendant voluntarily intoxicated with a non-dangerous drug may still have a defence unless they were reckless. In another case, R versus Hardy, the facts are the defendant took Valium, a mild sedative, to calm himself after an argument. He then became aggressive and set fire to a wardrobe. In this case, it was held that Valium is a non-dangerous drug. As the defendant took it properly and did not expect such effects, he was entitled to raise a defence. The court said the jury should have considered automatism. The principle established in this case, therefore, is that unexpected effects from a non-dangerous drugs may support a defence if the defendant was not reckless. Another question, and this one you might find the answer is an odd one. Question: can a defendant rely on involuntary intoxication, but who forms the mens rea for a sexual offence? In the case of R versus Kingston, which is an unusual case, the defendant could not rely upon the defence of involuntary intoxication. The defendant's drink was secretly spiked with drugs. While intoxicated, he sexually assaulted a young boy. It was accepted that he likely would have acted in this way if he had been sober. The House of Lords ruled that despite the involuntary intoxication, the defendant had still formed the necessary mens rea because his inhibitions were lowered. Therefore, he was guilty. The principle established here is where a defendant is involuntarily intoxicated, if they still form the mens rea for the sexual offence crime, they would still be guilty of the sexual offence, in this case, sexual assault. So, to summarise by making 5 points. Point 1, remember to consider 2 basic steps and questions when dealing with whether intoxication is a defence. Step 1, is this a case of voluntary or involuntary intoxication? And step 2, is the defendant accused of a specific intent crime or a basic intent crime? Point 2, voluntary intoxication may provide a defence to a specific intent crime if the defendant did not form the mens rea, as per the case of R versus Lippmann, saving one major exception, Dutch courage cases, as per the case of AG for Northern Ireland versus Gallagher. Point 3, voluntary intoxication is not a defence to a basic intent crime, as per the case of R versus Majewski. Point 4, a defendant may rely on involuntary intoxication as a defence to a crime of a specific or a basic intent crime, only if it prevents the formation of the mens rea, as per the case of R versus Hardy. And point 5, if the defendant did form the necessary mental element, even while involuntarily intoxicated, the defence fails, as per the case of R versus Kingston, which relates to a sexual offence. Now, in the next class, I will explore how the law deals with mistakes caused by intoxication in relation to mistakes and self-defense, and mistakes and criminal damage. Thank you for watching. Feel free to comment, follow, and subscribe for more.